Hi, friends, welcome to Learn to Unlock. In our previous video, we mentioned the various extended due dates regarding the filing of the income tax returns, relaxation in additional fee for filing the annual returns of the company. We mentioned that there are some practical difficulties with these dates and with other aspects. If you have missed out our previous video regarding the due dates, please do watch to get more clarity. Yes, friends, in this video we will mention few of the practical difficulties, especially with respect to companies, as these will have a high impact if not properly managed in synchronization with other provisions of various applicable acts. Yes, friends, by now all know that the due date of filing income tax returns of the companies is the 15th of February 2022. Management of the many companies are happy about the extension of due date, but they have not focused that the extension of due date is only for filing the income tax returns. Yes, friends, IT due date is only for filing of income tax returns. But the companies are not only regulated by Income Tax Act alone, but also has to comply with many other provisions, rules and regulation of various other applicable acts. One of the main acts which governs the company's activities is the Companies Act, 2013 and rules thereof. As per the Companies Act 2013, every company required to finalize annual reports including financial statements with respect to company's performance during the financial year, get it audited as per the provisions of the Act and conduct the AGM of the companies for approving such annual reports as per the provisions of the Act. Yes, conducting AGM within the due date specified under the Act is important. If not able to conduct the AGM within stipulated time, then need to apply for the extension of the time and get it approved by ROC. Yes, friends, the AGM to be conducted in time, but prior to that many other things like financial statement and other documents have to be prepared by the company, get the same audited by the statutory auditor. After the audit, there is need to get the financial statement signed by the statutory auditors of the company and obtaining the audit report based on the provision of the Companies Act, which are primary documents to be presented and get it approved by the shareholders of the company in the AGM. To conduct AGM, need to issue the notice for calling AGM which need at least 21 clear days from the date of signing financial statement, audit report. Now comes important aspect or practical difficulty, this time not from the Companies Act, but as per the provisions of the Chartered Accountants Act 1949. Yes, friends, you may be thinking how come the ICAI rules and regulations affect the companies as these are not directly regulating the companies. Yes, statutory auditors are chartered accountants who are regulated by the rules and regulation of the Chartered Accountants Act 1949. Now every statutory auditor, in order to have the authenticity, need to generate UDIN, which are necessary for issue of audit report of the company. The actual due date for generation of UDIN is 15 days from the date of signing. Now you might get the question that if UDIN is 15 days, how to generate? As actual date as per the Companies Act for AGM is the 30th of September. You might be thinking now we are almost nearing the end of November. Many companies with the mindset of the extended due date of income tax return deferred the preparation of financial statement and plans to get it audited. You might be thinking what is the consequences and how it will impact the business of the company. Friends, the consequences and penalty for failure to convene an AGM. If a company fails to hold an AGM within the time or extension granted, the tribunal, on its own motion or on the application of any director or member, may order an AGM to be held in accordance with its orders. If the company fails to hold a meeting in line with the tribunal's directives, the company, as well as every official of the company who commits the default, would be fined up to 1 lakh rupees. If the default continues, a fee of 5,000 rupees per day is imposed for each day the default continues. Yes, friends, we will make you understand in detail along with examples, the provisions, some relaxations as announced, and properly managing these dates for better compliances with all the applicable acts, provisions and rules thereof. Now, let us understand in detail important provisions one by one. First we will explain regarding notice to be given for calling AGM. Friends, every general meeting of a company may be called under the provisions of Section 101(1) of the Companies Act, 2013, by giving not less than 21 days clear notice in writing or through electronic mode, in the manner provided under Rule 18 of the Company's Management and Administration Rules 2014. In the case of private limited companies, the notice time can be 21 days or any other period specified in the company's Articles of Association, in short AOA. The proviso to Section 101, subsection 1, allows for an exception to the notice period requirement if specified criteria are met. The notice of meeting is a very significant and crucial part of running a successful meeting. This video will explain the provisions relating to shorter notice consent, as well as their applicability, requirements, and procedures for how a company can hold general meetings with less notice.
Friends, before explaining short notice, we would like to give good news regarding extension of AGM. Based on various representations received from many across the nation, for an extension of time to hold the annual general meeting, AGM, for the financial year ending March 31, 2021. The Ministry of Corporate Affairs, MCA, has advised the Registrar of Companies, ROC, to grant approval for an extension of time to hold the AGM, for a period of 2 months beyond the due date by which the companies are required to conduct the AGM for the financial year 2020-21. Yes, friends, the MCA has instructed each region's ROC to notify the extension of time for having the AGM for the fiscal year ending the 31st of March 2021. Since the MCA asked the ROCs to take up this matter as soon as possible, a number of ROCs, including the ROC of Karnataka, have uploaded an order giving a time extension. The ROC of Karnataka has also issued such an order, dated the 23rd of September 2021. The details of such order are as follows. 1. Whereas subsection 1 of Section 96 of the Companies Act, 2013, the Act provides, inter alia, that every company, other than a one-person company, shall in each year hold in addition to any other meetings, a general meeting as its annual general meeting, AGM, and shall specify the meeting as such in the notices calling it, and not more than 15 months shall elapse between the date of one AGM of a company and that of the next. 2. And whereas, the first proviso to subsection 1 of Section 96 of the Act provides that in case of the first AGM, it shall be held within a period of 9 months from the date of closing of the first financial year of the company, and in any other case, within a period of 6 months, from the date of closing of the financial year. 3. And whereas, the third proviso to Section 96(1) of the Act provides that the Registrar may, for any special reason, extend the time within which any annual general meeting, other than the first annual general meeting, shall be held, by a period not exceeding 3 months. 4. And whereas, various representations have been received from the companies, industry bodies and professional institutes pointing out that several companies are finding it difficult to hold their AGM for the financial year ended on the 31st of March 2021 due to the difficulties faced in view of the COVID-19 pandemic. 5. And whereas, the representations have been considered and the undersigned is of the considered opinion that due to such unprecedented special reason, the time within which the AGM for the financial year ended on the 31st of March 2021 is required to be held as per provision of subsection 1 of the Section 96 ought to be extended in terms of the third proviso to Section 96(1). 6. Now, therefore, in terms of power vested with the undersigned under the third proviso to subsection 1 of the Section 96 of the Act, I hereby extend the time to hold the AGM, other than the first AGM for the financial year ended on the 31st of March 2021 for companies within the jurisdiction of this office, which are unable to hold their AGM for such period within the due date of holding the AGM by a period of 2 months from the due date by which the AGM ought to have been held in accordance with the provisions of subsection 1 to Section 96 of the Act, without requiring the companies to file applications for seeking such extension by filling the prescribed Form No. GNL1. Explanation I. It is hereby clarified that the extension granted under this order shall also cover the pending applications filed in Form GNL1 for the extension of AGM for the financial year ended on the 31st of March 2021, which are yet to be approved. Applications filed in Form GNL1 for the extension of AGM for the financial year ended on the 31st of March 2021, which were rejected. Applications filed in Form GNL1 for the extension of AGM for the financial year ended on the 31st of March 2021, where the extension approved was for a period less than 2 months. Explanation 2. It is also clarified that the extension granted under this order shall not cover the applications filed in Form GNL1 for the extension of AGM for the financial year ended on the 31st of March 2021, where the extension approved was for a period of more than 2 months. Note, every company, other than a one-person company, is entitled by Section 96(1) of the Companies Act, 2013, to have an annual general meeting AGM by giving a notice to its members every year, with no more than 15 months between one AGM and the next. In simple words, it means between two AGMs gap should not be more than 15 months. Example, in the year 2019 AGM was conducted in the month of the 25th of August 2019. In the year 2020 AGM was held in the 20th of November 2020. If it conducted AGM on the 20th of December 2020, which is after completion of 15 months as per the provisions of section 96(1), it is not allowed. It will be like violation of the provisions of the Act.
Now, let us understand in detail important provision of short notice. Every general meeting of a company may be called under the provisions of Section 101(1) of the Companies Act, 2013, by giving not less than 21 days clear notice. In the case of private limited companies, the notice time can be 21 days or any other period specified in the company's Articles of Association. The notice of meeting is a very significant and crucial part of running a successful meeting. The proviso to Section 101, subsection 1, allows for an exception to that notice period requirement if specified criteria are met. Now you might get the question, what is shorter notice period? And what is the criteria for it? Yes, friends, short notice is the consent, permission received in advance by a company from its members to hold a general meeting at a time other than that which would ordinarily be called after the issue of notice. Friends, now you might get another question. What are the rules and regulation for getting consent for shorter notice? Yes, friends, there are specified criteria which provide it. That is, if approval is given in writing or by electronic means, a general meeting may be called with less notice than that stipulated in this subsection. In the case of an AGM, by at least 95% of the members entitled to vote at the meeting. Yes, let us explain with example. If the company has 100 members eligible to vote at the meeting, then for calling the AGM with a shorter notice requires the permission of at least 95 members. Consent can be given by members or a person with specific power of attorney, given on behalf of such member. It can be given in writing or electronically, such as by email, and must be received prior to the meeting's scheduled start time. Note, if no consent received prior to meeting time, then AGM cannot be held. Now, let us explain with few examples for better understanding. Example 1. Remember that the company has to complete first few things for issuing notice of AGM. Yes, friends, the company must complete the preparation of annual report. That is financial statement, director report, audit report issued by statutory auditor after conducting audit. With UDIN, yes, UDIN generation time normal 15 days. But now extended to 60 days considering the difficulties. Which means from the date of signing within this period UDIN to be generated to make to valid as per law. And other documents along with annexure to notice under Section 102 of the Companies Act, 2013. Yes, friends, all the above documents, notice to AGM to be signed first and having same date. Let us say all these got signed on the 8th of November 2021 and notice is sent to all the members, directors, auditors as per the provisions calling for AGM to be held on the 30th of November 2021. In this case the notice to AGM and for AGM has 23 days. It is a normal case of 21 clear days or more. UDIN is generated on say the 25th of November 2021 and all received the notice of AGM and AGM was held on the 30th of November 2021. Therefore, AGM held in time, extended time, valid as per law. Now let us give another example. Example 2. In this case all the documents got signed on the 24th of November 2021 and short notice is given for conducting AGM on the 30th of November 2021. Notice is sent to all say 100 shareholders, members of the company. As per provisions of the law, UDIN generated on the 29th of November 2021 and consent received from 95 members. And also from one person having specific power of attorney. Including this, it is 96 out of 100 gave consent before the 29th of November. AGM conducted on the 30th of November 2021 is said to be valid as per law, as it met the specified criteria of getting short notice consent prior to AGM time. Now let us give another example. In example 2 all the things are same, except generation of UDIN by the statutory auditor. say UDIN generated on the 23rd of December 2021 and same is mentioned in Audit Report and which is uploaded as a scanned document along with other attachments in Form AOC4, one of the form of annual returns to be uploaded in ROC, within 30 days from the date of AGM and with no additional fee till the 31st of December 2021. AGM conducted on the 30th of November 2021 is valid as per law. From the examples it is understood that we can conduct the AGM within due date and be a statutory complied company and avoid the legal consequences. Now you might think, we missed all the deadlines and did not conduct in time the AGM. There is one last ray of hope from ROC on filing the Form GLN1 seeking extension by 1 month. As per the provision of Section 96(1) of the Companies Act, 2013, that the registrar may, for any special reason, extend the time within which any annual general meeting by 3 months. Yes, friends, already 2 months extension is given by the ROC as per orders. Can request by 1 more month. If approved, then AGM can be conducted within the 31st of December 2021. Important note, please take action immediately and comply with the provisions of law and conduct AGM. Make sure AGM is held within business hours, say between 9 a.m. to 6 p.m. and not on national holiday, and shall be held either at the registered office of the company or at some other place within the city, town or village in which the registered office of the company is situated. Thanks for watching. If you like the video, please share to others for timely action. If you would like to receive such updates, please subscribe.